Good afternoon. Welcome to the last in this series of the Australian Government Legal Network seminars. This seminar, as you know, is on how different models for delivering legal services affect the development of legislative schemes. My name is Tony Walsh. I'm a senior drafter with the Office of Parliamentary Counsel, but also on the board for AGLN, and so I'd like to welcome you on behalf of the network. Today's speakers, you will be familiar, I suspect, to many of you. The first of our speakers is Peter Quiggin. Peter is First Parliamentary Counsel with the Office of Parliamentary Counsel. Parliamentary Counsel, as most of you know, is responsible for drafting principal legislation for the Commonwealth, such as acts. We're also responsible for drafting regulations and many of the legislative instruments that are produced for the Commonwealth. OPC also runs the Federal Register of Legislation. Peter's currently in his third term as First Parliamentary Counsel, and so will be very familiar to many of you. He was first appointed in 2004 and was recently reappointed for a further 5 years. He's been a drafter with the Office of Parliamentary Counsel for over 25 years. Drafters hang around for a long time. He's drafted legislation covering a wide variety of areas, and that includes things like taxation and immigration and native title. Prior to working at OPC, Peter was for a number of years with the Tax Office in the area dealing with instructing on taxation law, and prior to that dealing with the Administrative Appeals Tribunal. Our second speaker for today will be Susie Brown. Susie is a Senior General Counsel with the Australian Government Solicitor. Susie advises on a broad range of Commonwealth agencies, predominantly on issues such as statutory interpretation, administrative law, constitutional law and environmental law. She's had considerable experience working as on secondment as in-house counsel to a number of agencies, and that included the role of General Counsel to the Department of Sustainability, Environment, Water, Population and Communities. I think it's fair to say that Susie understands very well the everyday pressures faced by clients. Susie's worked on a number of major legislative reforms, including the development of the Carbon Pollution Reduction Scheme in 2009, the Product Stewardship Act in 2011 and more recently the Biosecurity Act in 2015. Before being at AGS, Susie was Associate to Justice Gaudron, and before that Justice Gray in the Federal Court. Our final speaker for today will be Simon Reiter. Simon is currently acting as Division Head in Treasury's Law Design Office. He rejoined Treasury last year as the Principal Advisor to the Law Design Office, and his role was to have responsibility for the markets and structural reform and legislation management within Treasury. Before that, Simon was General Counsel at the Department of Environment and Energy. He's worked as at SES level within the Department of Industry and on the Climate Change Project. Prior to that, he worked with Treasury and the UK Department of Trade and Industry in various roles, and has also begun his career in the private sector as a solicitor with Allens. So I might begin this afternoon. What will happen is we'll have the same format as we've had in previous sessions. So there will be 3 brief outlines of brief presentations, and then at the end of that there'll be opportunity for questions and discussion. I should mention that the seminar is being recorded, so if you have any colleagues who are unable to attend today, they'll be able to access it on a recording. We'll send an email out about that. So I'd like to now pass to Peter Quiggin from the Office of Parliamentary Counsel.
What we're going to have a look at today is different instructing structures in departments and the strengths and weaknesses of those, and the sort of things that need to be taken into account depending on which sort of structure you have. I'll give a sort of a general overview of the various different structures that we see from OPC's perspective and the points that you need to consider for each of those different types. Susie will then sort of focus more on what legal people in the system need to look at, and then Simon will actually look at a fairly specific case study and sort of bring it all together, looking at how Treasury have implemented their instructing process. So when I was asked to give this speech, I thought it'd be a useful idea to ask the drafters in APC what they thought, and so we had a meeting, and the first thing that the drafters came up with was that the structure is not actually as important as the skills and experience of the instructing team and how well they work together. And perhaps when you think about this, it may sort of end up being obvious, but it really is a fundamental thing that it's really the people that we're dealing with and the way they're working together rather than the particular structure that tends to determine whether or not a legislative project will go well. And I think one of the reasons for this, the other thing the drafters came out with, is that we see instructing as an important skill that needs to be valued. So we actually see instructing as a specialist skill. It's not, so in the same way that other skills are learnt on the job, etc., some people will be better at them than others, but it's something that actually is different from just being a policy officer or just being a lawyer. It's something that the more you do, the better you get at it, and it's something that people need to actually be trained in how to do instructing. Coming out of that is a view that we have that departments need to develop and also to value their instructing staff. And I think we see this at different levels across the Commonwealth. Some departments have particular areas where they sort of work on developing instructing staff, getting them to work with more experienced instructors. Others just sort of seem to get a job, wander down a corridor and sort of the first available person give it to and say, yeah, you've never instructed before, you've got nobody around you who's ever instructed, but have a go. Certainly we think departments need to both develop and value their instructing staff. So moving on to the sort of different structures departments may use, sort of looking at who's involved in the process, and this is probably the people, I'll look at sort of who's sort of directly involved with OPC in these processes. Those first group of people that are in legislative projects are the departmental policy area, which is responsible for developing the policy. So within the department, there'll nearly always be a particular policy area that has responsibility for any particular project that comes along. Another area that we deal with regularly is the legal area, and it could be a departmental or possibly external legal area, which is responsible for providing legal advice to the policy area. The third one is our office, the Office of Parliamentary Counsel, which, as Tony mentioned, is a specialist drafting office. And our job is to analyse the policy and then prepare the legislation. And the final group I was just going to mention are the administrators or regulators. So they're the people who actually have to implement or administer the legislation. Sometimes there'll be an overlap between them and the policy people, but often they'll be a separate group. So we've got those four players, and basically what I'm going to look at is the different ways that we see they're organised in the legislative process. So the first model, which is probably perhaps the traditional model, the model that was used numerous years ago for nearly all departments, was where the policy officers would do the direct instructing. And so in this model, we have the policy people working directly with the OPC drafters. There's probably legal people off to the side, so they may be getting advice during the preparation of instructions, they may be providing advice as we go along, but they're not sort of directly involved with OPC. And similarly off to the other side is the administrator or regulator, so they will have some involvement, but again, not particularly close involvement in the direct instructing and drafting process. And looking at this, the advantage of this is that the policy area remains closely involved throughout the whole process. So when you consider the whole point of the drafting process is to take a policy and implement it into legislation, having the policy area closely involved throughout is obviously a great advantage. However, there are a number of disadvantages, and the first is that it relies on the policy area being very skilled in instructing and also knowing the legal issues, so knowing when they'll have to get advice. And again, in some areas this will work well, but if it's one where so you've got a department with 50 different policy areas, it's unlikely that all of those 50 areas will actually have people who over time have been skilled in instructing. What we have found with this structure is that generally instructions are often not well developed when they come to OPC, so they can be very general. I've even seen some that are so general that they actually just repeated the bid that was given to Parliamentary Business Committee. We did have one set a number of years ago which said, this is the policy outcome that the department wishes to have. OPC should not restrict itself to one approach in determining how to do that. That was a little bit a step too far. But we do find, even when it's a fairly narrow issue, that the instructions are often not well developed if we haven't had the other areas involved. This means it requires greater input from OPC, which can be problematic. Probably the worst model is where you have the legal people off to the side and you go to them right at the end. So you've done the policy, you've got the draft, here's the draft, they then send it off to legal, and legal find there's some fundamental problem, so get back to square one. Similarly, getting the regulator involved right at the end and saying, here's what we're about to do to you, or for you, is a similar problem, that if at that point they say, no, the whole thing doesn't work, there's difficulties. The second model I'm going to look at, which has become more popular in a number of agencies, is one where there's an interposed legal area. So there's a legal area in the department that has the role of providing instructions on all legislation. So I think Home Affairs is one, or Immigration before, in the pre-Home Affairs days, was one that had specialist legal areas that provided instructions. So they would get advice from the policy areas, would tell them what they need to do. They would work up the instructions, and OPC would work directly with the legal people. At some point, with other areas, there may be an administrator or regulator who's again off to the side, so the policy people would be talking to them. So this, as I say, was a common model across a number of agencies for some time. Again, there's advantages with this. The instructions are usually better thought through. So they've been developed by the policy people, they've gone to the legal people, so they've had that sort of second review and input from people who know about legal issues. So the legal issues are usually addressed early in the process. We don't get way down the line and then find there's issues that haven't been addressed. There's usually or often less turnover in those areas, those central legal areas, and so the instructors tend to end up being more experienced. And if nothing else, even if the level of turnover was the same, you've just got sort of one area compared to if you've got sort of the 50 different policy areas. It's very difficult to get the same level of experience spread across that policy level as opposed to one core legal area. There are disadvantages though, of course, Chinese whispers. So if you recall the last slide, we had the person implementing it, the policy person talking to the legal person, talking to the drafter. So if there is an issue that requires some input from the regulator, OPC will say to the legal people, what does the regulator think about that? They'll ask the policy people, who will ask the regulator, who will tell them, who will tell the lawyers, who will tell OPC. And by the time it's gone in both directions, it's likely that the two messages are, the answer you get will be rather difficult. Another disadvantage with some that can happen is the policy area may become disengaged. The policy area may view this as a process where they produce the original policy, hand it to legal, and then sit back and not have any further involvement. And that's obviously problematic if we're going back saying, well, how should the policy work? It can be difficult for the legal area in some cases to get the policy area involved if they see legislation as something that's not there for them to do. A slightly different problem is where the legal area becomes a postbox, and by that I mean OPC says, what should we do about this? And they get our email, they press forward and send it to policy. Policy get the email, open it up, type some stuff in, send it to legal, who press forward and send it back. Probably the best example I've got of this is I got some instructions once and I read them and just couldn't work out what they meant. So they were in response to a question I'd asked and I just couldn't understand what they meant. So I rang the instructor in the legal area and said, I got the instructions but I just can't understand them. And they said, yeah, we couldn't understand them either, so that's why we sent them to you. So the legal area has to be active and, as I say, certainly not just a postbox. And part of that is drafters need some access to the policy people. I think it's sometimes in the past some people have had a real wall that the drafters never deal with the policy people. It's much more useful if the drafters have some access, even if it's with the legal people, to the policy people. The third one I wanted to look at was probably one that's used more these days, which is the policy area primarily instructing, but with close involvement of the legal area. This, as I say, is a much more, or one that's used in a number of agencies these days, and probably reflects, I think the change over time probably reflects the rise of more complex legal issues in policy development. Again, the advantages of this, if you've had that early legal involvement, instructions are usually better thought through. Again, the legal issues are generally identified earlier because there's been that involvement. The policy area remains engaged. By having the policy area as the primary instructors, they remain engaged in the process. The main disadvantage, it still relies on the policy people being able to instruct and being skilled in instructing, as they're the ones actually providing the instructions. The one thing I also just wanted to mention quickly was involving administrators. So we've seen those in each of the slides sort of hiding off to the side. It's important to involve the administrators or regulators throughout the process. They actually understand how things work on the ground, and they're also the ones who are actually going to have to implement the law. They bring a particular knowledge and a particular perspective which is often very different from the one the policymakers may have. I'm not saying the policy people should defer to the administrators in all cases. I think you need to be aware that administrators and regulators will have a particular view of the world, and that may not be the view that fits the particular policy. And so, again, they need to work with them and filter those comments. And it's often useful to have the regulators at some point involved with the drafters. Also just wanted to mention one other aspect involving AGS for legal advice. As you're probably aware, under the Legal Services Direction, advice on legislation has to be provided by AGS, so it's tied to AGS. So you may find that if a legal issue arises in a drafting project, the drafter will say, we want you to go to AGS for advice. And basically our view is that role is tied, and therefore both can't go out to a private firm and can't be done in-house. There'll be a whole lot of other legal work that can be done in that way, but where there's specific advice, we think AGS needs to be involved. And I think if we've got one of these projects, so often the drafters will look at it at the start and think, oh, this has got particular issues, often constitutional ones, it's important to involve AGS throughout the process for the projects that need their input. Again, it's pretty unproductive if we say, we think you need AGS advice, oh yeah, we'll get that at the end, If we get to the end and AGS say no, that's all back to front, that can waste a lot of time. Again, AGS bring particular knowledge and perspective to issues. They've seen a lot of these issues from across other areas of government. And it's, again, often useful to have them at meetings. So I realise departments need to pay for AGS to attend, although I read that they're now going to a cost recovery model, so no doubt there'll be bargain basement prices. But it is useful to have them actually at the meeting so that, again, you don't get the thing where the drafter has to try and explain, perhaps a non-legal instructor, a legal issue and get them to try and explain that to AGS. I think it can end up actually being a cheaper way in the long run. The one other thing I just wanted to mention quickly was outsourcing the instructing function. So this may be something, if a department doesn't have the skilled instructors, they may wish to look at outsourcing the instructing function. So it's something that, as I say, we've seen a number of agencies do to overcome skill shortages, either short-term or long-term. We've found it's worked pretty well where AGS has taken on the role, although again, AGS still need to have access to the policy people. You can't say to AGS, well, can you instruct on this project and walk away? They obviously need to have close contact with the departmental people. And so those policy officers really need to remain fully engaged. So hopefully that's given a an overview of the different things and some of the things that people need to look out for. And so now Susie will come and focus on some of the things of particular interest to the lawyers involved in the process. Thank you.
Thanks, Peter, and thanks to the AGLN for having me come and speak today. Peter's covered off different instructing models. I'm going to focus, as he alluded to some of the different ways in which you can involve lawyers, not so much as instructors, but for the legal advice function in the drafting process. And I think my comments cover to some extent both internal and external lawyers. My observations are based mainly on my own experience as an AGS lawyer on a number of large legislative projects. But in working on those projects, I have often, although not always, been outposted to the relevant department. So I hope I bring a bit of and in some cases, like my current role, I'm embedded in their legal area, but supporting a number of legislative projects. So I hope I at least to some extent capture the perspective of in-house lawyers as well as AGS lawyers. So there's a wide range of models or ways of engaging lawyers in legislative projects. These are really by way of examples, and we see they're a bit of a spectrum, I suppose. The lawyers can be the instructors. Peter's largely covered that issue, and so I won't touch on it further here. I must say, while AGS is engaged to be the instructors, it's not been my own experience. I've usually been part of a team or assisting the instructing team. The lawyers can be embedded in the policy team. I've worked in this model where you've got a very large legislative project. You essentially put together a task force type structure. And the largest one I've worked on, they started with me 3 days a week and they ended up with 5 full-time AGS lawyers. So that ramped up over time. And I think reflected the complexity of the legal issues and also just the sheer need to support the instructing function. As I alluded to, the lawyers might also be part of the in-house legal team. You might actually be members of that team or seconded lawyers in my case. You can have a virtual secondment type model. I've also worked in this model where on the biosecurity bill, half my time was dedicated to that bill. Every time a constitutional advice issue arose, they could just come to me. It made certainly the procurement easier from their point of view, but it also enabled me to have that continuity of perspective over a bill that ended up being about 400 or 500 pages long. Or you can have a dedicated team of external lawyers. Obviously, they'll be working on a range of things, but you always go back to that particular individual or team. And the last one is responding to ad hoc requests. When the policy area realises they need legal advice on a particular thing, or as Peter alluded to, sometimes OPC will say, you need AGS advice on this particular question. So the choice of models likely to be influenced again by a really broad range of factors, and these are just some of them. The size and the complexity of the project, if it's a very small project, relatively simple, probably doesn't justify some of the more intense models of legal involvement. The nature of the legal issues that are likely to arise. So an example of that would be if you've got complex constitutional issues, so at least 2, maybe 3 of the schemes I've worked on, a lot of the schemes I've worked on have been in the environmental space. One or a key constitutional power underpinning that scheme might be the external affairs powers engaged by various international conventions. That provides, in many cases, quite a complex set of issues to underpin the scheme, and so more intense involvement by AGS is probably justified and required. The model departments choose might also depend on the experience of the instructing team in dealing with legislation. Again, Peter's touched on that point. I think the less experienced the instructors in dealing with legislation, the more likely you are to need significant input from the lawyers. If only, they might do a first pass at the drafting instructions, interrogate them before they get to OPC. And of course, cost will influence the choice of model. In the time remaining, I thought I'd touch on two themes to consider, I guess, when you're choosing a model and when working at designing and working on a legislative project. In my view, there are very, very significant benefits in having continuity of the legal team or the individuals in a complex project. In my view, of those models I mentioned before, which precisely of those models you choose are perhaps less important than the fact that you have continuity of the particular individuals involved. And really, I guess I'm looking at the middle three, whether the lawyer's embedded in the policy team, whether they're part of the in-house team, or whether they're on some sort of virtual secondment arrangement, I think is probably less important than the ongoing involvement. The two key ways in which I think this really assists both the end product and the process, I think it contributes to the robustness of the legislation, and it also assists in communications. The ways in which it can contribute to the legal robustness, I think, is, depending on the project, it can be useful, if not almost essential, to have legal advice at the design stage, even before the instructions are issued. So again, I guess from my perspective as a constitutional lawyer, the constitutional basis of the scheme can really influence the design, and really those issues need to be thought through before you even get to OPC. An example of that might be the department comes up with its preferred policy, it then goes to AGS for constitutional advice. The result of the AGS advice indicates that actually there's very little or limited constitutional powers, or that there's large gaps in the constitutional coverage. You might at that stage decide that a referral of powers from the states is the way to go. Obviously that has significant design and timing implications, and would require significant input from the lawyers. The other ways I think it can contribute once, I guess, the process has started is if you've got the same lawyer involved in reviewing, in advising on and reviewing the legislation, I find from my own experience you are far more effective at spotting issues. I think there is limited value, very limited value in, and Peter touched on this as well, in giving a lawyer a complete piece of legislation, particularly a longer, more complex one, and saying, what are the legal issues, what are the constitutional issues? Your eyes glaze over as you read it page by page, no offence to my colleagues at Office of Parliamentary Counsel, but you just simply don't have enough understanding of what it's designed to do, where the pressure points are likely to be, where the challenges might come. So in my experience, if I review a bill that I've worked on, while obviously I will no doubt miss issues, I'm more likely to be able to spot issues and concerns. And that might be constitutional, it might be administrative law issues, it might be how's decision making going to work under this bill, those sorts of perspectives. I think that having a lawyer involved in a project, almost no matter what their expertise, they're more likely to be able to suggest opportunities for, or good points at which to draw in lawyers with different expertise. So, for example, if I'm working on a bill and it's got criminal offence provisions, I tend to say, are you going to test those with the Commonwealth DPP? You're going to test those or for civil penalties, you're going to test those with an enforcement lawyer, with the lawyers of the regulatory agency. It's a long time since I've done civil penalty work, so I don't regard myself as far from an expert in that work. But I will tend to recommend to clients they consider those things. Having said that, so I think continuity is really important, as you can probably tell, in a large and complex project that justifies those sorts of resources. But I would mention that I think that there is value for lawyers who haven't been involved in the project doing some advice work on legislation. In my current role at Agriculture, we've suggested a few times a sort of stress testing exercise, which might involve coming up with a few scenarios or a few key legal issues where the bill really needs to work. You really need to be able to take regulatory action, or you need to ensure that these complex provisions do work extraterritorially as you think they do. And I have certainly found it valuable, and I know in at least one case the OPC drafter has. When we drafted up, I drafted up the request for advice, but it went back to a colleague who'd not seen the bill before. So I think there is a risk with any project that you get too close and you stop seeing the issues. Thankfully, they came back and said it did work. I guess you've got to be fairly robust and communicate to your clients that when you do that, it might come back saying it doesn't work, but I think there is real value in times in involving lawyers who haven't had that close involvement. The other benefits of continuity Peter has touched on, and this really reflects my experience as well, is the ability to have direct communication between OPC and the lawyers and the instructors, and a three-way communication. I think you get better solutions that way. I also just think you get faster and much more effective advice. For example, if I'm working on legislation and there's square bracket comments, OPC, requires constitutional advice on this issue, I'll almost always ask if it's okay if I call OPC with the instructors present or not, as they prefer, to talk through the issue, because OPC are good constitutional lawyers in their own right. They've raised the issue for a reason. They might even have a possible solution up their sleeve, but that's something that tends to come out when you have that discussion rather than writing. And similarly, if I'm communicating directly with instructors, policy people, the in-house lawyers, I get a better feel for what the real issues are and what might work from their perspective. So I think when the three of you are involved, the OPC, the lawyers and the instructors, you can often brainstorm a better solution than one particular party can come up with. The other theme I thought I would touch on is the importance of capturing knowledge and skills developed on a project, and that applies to both policy/instructing skills and the policy deep, I guess, understanding from policy perspective of the scheme, as well as the legal skills. And I sort of think this falls into sort of two categories. One is capturing the documentation, and I referred on the slide to drafting instructions and explanatory materials, but I should also add, of course, advice on scheme, making sure that it's captured and it's boring but filed and put on databases so that it's accessible. Obviously, AGS has its own databases for doing that, but in-house areas do too. Capturing drafting instructions, I guess as lawyers sometimes we think, well, you don't need to look at the drafting instructions, they're not a legitimate extrinsic aid to interpretation. But I have had the odd occasion where the policy area has been able to locate the drafting instructions, when I'm being asked to advise on future amendments, and that's given me a level of comfort that I understand what the underlying driver was for a provision in the first place, and hence more confident in saying, I think you can get rid of it now, or whatever the question I've asked. But perhaps more importantly that of course is the explanatory materials. And I guess the thing I wanted to say here was you kind of get one shot at putting together materials that you can legitimately use, a lawyer can legitimately use as an interpretive tool going forward, and that the courts will refer to varying extents. So I guess it's to say I think it's important to have the right people doing them and invest enough time and resources in doing them, and ideally that's both the right policy people and the right legal people, because I think it's a bit of a combination. Policy people understand why the provisions were put in, the legal people can make sure that the EM is not technically incorrect, which does happen on occasions. So I guess it's by way of saying, please don't give it to the new grad, which is not an uncommon thing. And I understand the pressures. I've worked on projects. I know that often, there's literally days between finalising the bill and having to have it up in the minister's office, or perhaps that's generous timing. Sometimes it's less than several days. But that just means you have to try and manage that project as you go along. And one other tip I would have is to keep a log of issues as you're working on a project. So it's not uncommon for OPC to say, instructors, please say this, explain this in explanatory materials, or AGS to say, from a constitutional perspective, it'd be really good if you could explain here the connection between this and, the relevant international conventions. That'll assist if there's a constitutional challenge. It's really easy in the hurly-burly of finishing a project to forget about those issues. You've got 50 drafts, you don't want to go back through them, finding each issue you were supposed to put in the EM. So it's just a practical thing to think about. The other aspect of that is capturing the expertise of individuals, both policy and legal. When you're setting up a team, ideally you might want to think about, are these people still going to be available to advise on and work on the implementation of this legislation in the future, or if we've brought in a contractor, they're going to go. Succession sort of staff planning issues, you know, if a whole new regulatory scheme's been set up, and I've worked on a few, although they haven't always passed, should some key staff, both legal and non-legal, actually move into that regulatory and administrative function, so there's some corporate knowledge. Another way of dealing with that, which I've worked with recently, is I was paired with a less experienced lawyer from the in-house area. She was a very good lawyer, but she hadn't done a legislative project. That gave an opportunity for skills transfer, but it also means when I move on back to AGS, there's someone in the in-house area who was involved in this project. And I think consider opportunities, whether it's seminars, workshops, just face-to-face meetings, to pass on some of that knowledge between the team that we're instructing and advising on it and the team that now have to implement. Too often I have seen there be very little overlap and connection between the two, and that makes implementation harder. So in conclusion, they're just a few select issues, I guess, based on my experience, to think about when you're managing a project. And deciding what model for your instructors, but also what model for your legal input. I think it can lead to a better designed project and more robust legislative scheme, and hopefully a smoother implementation as well. So I'll hand over to Simon.
Right, so I'm going to give a perspective which I suppose draws in the policy point of view. But to begin with, I might give you a little bit of context about where Treasury is at, because that really shapes, you know, where these observations have come from. So Treasury's OPC's biggest customer. In the 45th Parliament so far, we've introduced 109 bills, and that's about 3,100 pages of legislation. So to give you a sense of scale, the next three biggest departments, which are Finance, Social Services and Attorney Generals, have done about half that in terms of the number of pages, and about a third of the number of bills. So we're kind of a factory for producing primary legislation. We also produce a lot of subordinate legislation. We're also dealing with quite a range of issues. So we look after the tax system, we deal with the regulation of corporations and the financial system and financial services and banking and insurance and life insurance and superannuation and various other bits and pieces as well. So there is a lot of kind of diversity and complexity going on in what we're dealing with. So that volume isn't simply replicable work, it's quite complex in many cases. So this is sort of sense of range and scale, and that has given us a lot of opportunity to think about the way we do what we do, and also the aspect that often gets neglected, which is around the delivery aspect of getting through legislation. So that's a bit of context about what Treasury does. The thing I think that's instructive always to remember, though, is that legislation happens through a complicated set of relationships. It's not a kind of neat sequential activity, but this sort of interaction, even for relatively simple measures, that means that there are all sorts of considerations and consultations and service engagements and things like that that are going on to get a piece of legislation either into the Parliament or through the Executive Council, or a subordinate instrument to be made by a minister or other decision maker. This is the sort of perspective, the pre-Copernican kind of perspective that the Law Design Office has, which is that we sit in the centre of everything, and the rest of you will kind of rotate around us and hopefully do what we want. But what we're trying to sort of articulate when we think about these things this way is that when you're planning a piece of legislation and thinking about what to do, these kinds of considerations have to be borne in mind from the very beginning, and not as a sort of afterthought about, well, you know, I've been given this job to do, let's focus on the content and get on with solving the problem because that's what the Minister wants, rather than thinking about how to get there and get the outcome that we're after. So the way, sorry, I'm going backwards. The way that we think about it is what we want to do is deliver the best possible legislation which achieves the government's policy intent and timeframes while minimising risk and complexity and taking a whole of system perspective, whatever system that might be in the Treasury context. There's a few things to sort of pull out of that statement. We talk about best possible legislation, where when we think about that, what we're thinking about is what can we do in the time that we have to do it, rather than what is the best piece of legislation we can produce given unlimited time and resources. And then the other kind of lodestar that we all have to bear in mind is what does the government actually want to do, and when does it want to do it by. In Treasury, we run a very complex process of thinking about the priority of legislation. We deal in what we call measures, so we don't think about them in terms of bills. Sometimes we'll have half a dozen or a dozen measures in a bill, and other times we'll have a measure that covers 5 or 6 bills because we've got revenue imposition bills and things like that that are necessary. But we're engaged in a continuous process of thinking about, well, when are things necessary? When does the Parliament want, or when does the Minister want these things to come before Parliament? And how does it sit in the broader agenda that the government has around, in our case, the delivery of kind of economic policy and regulation, and dealing with those sorts of things. Going back to the point I made before about planning and thinking about these things from the outset, the minimisation of risk and complexity is critical to what we're trying to do. The Corporations Act nowadays is about 3,600 pages long. No one is pretending that that's not a complex piece of legislation. The tax acts are multiples of that. We're trying to think about these things from a system point of view rather than applying more and more band-aids to already complex systems. Now, it may be hard to distinguish between whether or not we're applying actual band-aids rather than taking the system perspective, but it is something that we try to inject into what we're doing from the outset, and think about the way that these things are delivered in terms of the risk in the delivery process itself, but also the risk to the system and how it operates in the longer term from a regulatory or administrative point of view. And these are sort of critical things not only for the people in Treasury who think about legislation and how to deliver it, but our policy colleagues as well. So I personally think that what's successfully needed to implement policy through legislation is that collaboration is central to that model. So where we've got kind of highly transactional demarcated structures, then that really does generate risk. And Peter talked before about situations where instructions are sort of passed through without any real appreciation of what the issues are or the complexities involved, and that really just sort of backloads the problem onto OPC to try and work out what is going on and what is needed. This observation applies to anything else. We have similar views about the way that Treasury deals with revenue costings or the development of our regulatory processes around foreign acquisitions. The kind of lack of collaboration leads to gaps or leads to duplications that then lead to problems. The other thing that is critical in getting these things right is engagement between the different parts, the different actors in the system from the earliest point. And that's not just about the policy aspects of what we're doing, but the actual delivery process and making sure that there is a real sense in which people are part of the process discussion as well as the content discussion to ensure that what is achievable is realistically managed and that expectations and understandings about timeframes and what will be done at a particular time and when things will go out to consultation and when instructions will go to OPC and when OPC will get those things back to you and what the Minister is dealing with will all be managed in a way that everyone in our kind of legislative development paradigm is thinking about and aware of. In Treasury, as I outlined before, we're dealing with quite a diverse set of rather sophisticated schemes, and the views of regulated communities are critical to that. And then there are obviously broader perspectives that come in from other interested groups and the sort of public generally that need to be integrated into the process from the outset. Part of the challenge when we're dealing with volume is that time for consultation and engagement around the development of legislation can slide, and so that there is a sense in which we're simply churning through it and sort of getting it into the Parliament without necessarily finding enough time to consult. That is something we're continually working on and trying to improve. But when those things are absent from the process, the risks around the development of a piece of legislation being what the government actually intended and can deal with when it actually gets into the Parliament are much, much greater. So this is a bit of a list. I won't go through each of them in detail, but one of the things we've been thinking about a lot in Treasury is in Treasury's Law Design Office is how policy areas can get the best results out of a legislative development process. So some of these are fairly obvious propositions, like whether legislation is actually needed and what the other options might be. I've talked a bit about the engaging early and often. One of the things that people can perhaps be a bit allergic to is this sense that there is a process and that they need to think about that. People tend to see these as constraining and sort of coercive exercises rather than actually being a way of assisting in delivering a legislative project and getting it achieved in the timeframe that's expected, and using those sorts of tools around project management and deadlines as really signalling devices to allow for the raising and escalation of issues and managing those in a timely way, rather than what can happen, which is that all of the issues coalesce at the very end because there are a set of micro decisions made about a piece of legislation in development that then lead to a point, generally just before you hit the Minister's office, that you've got to sort it all out right at the end, and that's problematic. The other thing that policy areas can struggle with, and this is certainly a real issue where you're dealing with major complexity in the regulatory and legislative schemes that you're administering, is that sense of what the policy is actually intended to do, and keeping that very much at the forefront of the legislative development process is critical to success. Otherwise, the risks of drift and a lack of focus become very real. Coming back to thinking about the way that a policy area approaches the legislation, where we have a demarcated structure where they say, here's the policy idea, now just go and make that into a 50-page piece of legislation, please. That is, well, one, very difficult to deal with, but secondly, it is quite difficult when the policy area can focus on the content without really thinking about the principles underpinning what it is they're trying to do and how they relate to the intended outcome, and whether the policy really fits with what is in the existing scheme or not. These sort of things can then come back and create more and more problems, and we have certainly found that in many cases in dealing with OPC over the years, where a lack of clarity and certainty about what the policy is meant to do and how to actually get to the result leads to very significant issues in the way that legislation is drafted, which really leads into this question about whether people are focusing on the substance or the form of what they're doing. Too often there can be a focus not so much on what's intended to be achieved, so much as trying to look at the piece of legislation and think about whether that works, and then providing lay drafts and all those sorts of things that drive drafters mad. So really kind of getting to that sense of the intent and how the policy is being executed rather than getting caught up in the precise words. And part of the job of an instructor is really to think about and manage those sort of sensitivities so that we don't get bogged down in these kinds of problems. And then, of course, the main thing that any instructor and OPC want is that the policy people actually know what it is they're advising on, because the capacity of any of us to fill in the gaps is very challenging. So to talk more about the way Treasury does it, I've kind of adapted Peter's model a bit. We have developed this concept of law design, so we don't think about it just in terms of instruction. What we are trying to do is create a discipline which is about, yes, having good people who are very capable at providing coherent and clear instructions to OPC, but are actually taking a much broader perspective about the legislation and the legislative schemes that they're dealing with, and drawing together the legal perspectives and the policy perspectives and the views of regulators. And in the Treasury portfolio, as I'm sure is the case elsewhere, we have some very big and sophisticated regulators who have far more depth and knowledge about the way the legislation works in practice than the department ever will. So the Law Design Office in Treasury is meant to fulfil this kind of intermediary function. And it's a multidisciplinary activity. It's got lawyers in it, it has economists, it has all sorts of other people. And we also have a unit that's focused on legislation management and dealing with the process issues, which is not just about the kind of transactional dimension of getting something ready and into the Parliament, although it's a very important part of its role, but also looking at the entire program and how it fits together, and thinking about project management for these measures and ensuring that everything is proceeding and being managed and risks are being identified and dealt with in a very timely way. When we think about the skills we want for people in our area, we're not just after the fact that they have a technical capacity around legal things or a particular policy discipline, but that they're also bringing sensibilities to bear about project management and consultation and collaboration and all of the things that we want them to do to ensure that we're in a position to try and give the government the best legislative products that we can within the timeframes that they want to achieve. We don't act, though, as the sole intermediary with OPC. So there are two other dimensions in Treasury, which is we deal with a lot of costing analysis, which is around revenue measures, which are a very big part of our business, and then there's the policy analysis as well. But getting back to the point I was about to make, we're not the sole intermediary. We do allow and try and encourage our colleagues to engage with OPC, but we help manage and intermediate that process so that OPC is not overwhelmed by them. And where that works very well, given the complexity of what we're dealing with, it is, I think, and perhaps Peter and Tony can disagree, but it seems enormously valuable to getting the right kind of outcome for the legislation, because for the reasons that Susie and Peter have talked about, having those different perspectives and that greater depth around particular issues, particularly given the technical content of what we're dealing with the Tax Law or the Corporations Act or any number of our other regimes, we don't have all of that sitting in Treasury. We're a relatively small agency. So the way that we think about it is that it's more than just instructing. It's this concept of law design. It's meant to be an integrated process. I won't go through all of these things, but what we're trying to do is make sure that we get a legislative product that is managed well in the delivery and integrates all of the perspectives that need to be brought to bear in ensuring that that legislative product, one, meets the government's policy intent, but also does so in a way that's mindful of the legal constraints within which it operates and the broader kind of regulatory and administrative and economic context in which it is going to work as part of the statute book in the future. The critical thing for us is having that multidisciplinary perspective that's brought to bear on these things, and the Law Design Office is meant to create an opportunity for that to happen in a more formal sense, because as I said at the outset, conceiving of legislation in a kind of neatly sequential and orderly way is a fairly, I think naive, but also risk-creating way to consider these things. And so we're trying to drive a model where we try and integrate these things and have something which can meet the needs of all of the different actors in the process at the same time as creating a sustainable and effective way to deliver a very large legislative volume. So thanks very much.
Thank you to our speakers. I thought we've got some microphones coming around, so we might invite questions from the floor to any of the speakers. I'll ask you if you wouldn't mind to identify who you are, where you're from, and which speaker you'd like to direct the question to. And there's silence. Yep, over here. Thanks, Alex.
Hi, my name's Zoe Cameron. I'm from Department of Prime Minister and Cabinet. I've got a few questions, but we'll see if anyone else has any. But firstly, I wanted to ask Peter, you mentioned early on the importance of training for instructors and having really skilled instructors. And I'd just be interested to hear a little bit more from you about how you see that might happen, if you know of areas that do it well and how it's done well. Apart from the obvious of kind of doing it multiple times and doing it over a long period of time, are there other ways that people that are new to the instructing process can be trained?
I think so. There's OPC run legislation process courses, which is a legislation process course and an advanced one. And I think for anyone who hasn't done instructing, that's almost a prerequisite. Like, it really does give an overview of the whole process and draw out a whole lot of things that are not obvious. I think one of the things about the legislation process is there's a whole lot of stuff that is counterintuitive or just isn't something you'd come across in your normal day. A number of departments have built on that. I think Treasury do have some programs where they deliver to their staff fairly structured training on aspects of instructing and policy development. As Simon has said, they've got a slightly different process, so they probably try and train a broader range of things. I'm certainly aware other departments have similar sorts of things. Many years ago when I was with the tax office, even at that stage, they had an instructing program which I think ran for about a week, and people did actually a practice instructing thing as well. So I think there's certainly a lot of potential for agencies to do that, and I think again probably this group is one that could actually share sort of information about what other agencies are doing. I think another aspect that is very important is sort of mentoring arrangement. That really the best way to learn this is on the job, really working through a project, and if possible, having a senior person who's experienced with it work with a less senior person, and so develop them to have that. I think again that's where it's probably a bit easier in the larger departments like Treasury that have a constant flow of legislation. You can do that more, but I think even in some of the departments we see that have fairly large legislative programs, there doesn't seem to be a great attempt to actually, for each project, have an experienced person working with a less experienced person. But I think that's another way. So as I say, there's probably three I'd give are the courses OPC run, which at a relatively basic level, departments running their own, and a mentoring sort of process.
Thanks.
You might want to hold the microphone.
Up the back, I think. Kaylee.
My name's Elizabeth. I'm from the Department of Home Affairs. My question's for Simon. You've talked about a model that's a bit different to what exists elsewhere, and the importance of the law design area in that. And you spoke about what it's trying to achieve. Could you give a bit of insight as to how it achieves it, other than just having an area that's sole focus is to assist in the coordination?
Well, I can probably talk about that at some length, but I mean, part of it is having a kind of area, which is not an uncommon feature in departments, and I know other departments have it, that are focused on the task of delivering legislation and making that happen. The added bit that I think we're focused on is around the kind of building of structures to foster collaboration across the department and with our regulators and with other parts of government, and also around the mechanics of doing so. So rather than relying on a lot of kind of good luck and goodwill and people's good memories to get things done, we're implementing a much more structured approach to project management and delivery, which is really focusing on there are kind of two aspects of this. There's the process and the content, and the default often, particularly with professionally minded people, is to focus on the content rather than the process. And what we're investing a lot in is the process dimension to try and improve the way that this flow is managed. 5 or 6 years ago, Treasury had no central management of legislation. It still had similar volumes. I know that caused enormous headaches to OPC. It caused enormous headaches in Treasury as well. And so we've seen what the alternative looks like, and it's not very pretty. So what we're trying to do is, and certainly working on it and achieving some success in getting there, is really injecting a degree of discipline and focus into the process of delivering legislation across a diverse range of issues, rather than kind of hoping for the best.
Is there anyone else? Yeah, down the front here, perhaps. Down here, Kalia.
Hi, I'm Francesca Neely from Attorney General's. I'm just interested in how OPC prepares drafters to engage with these different models of instructing, and is it through, say, having some drafters being working on legislation in particular portfolios where there will be one model, or because it seems to be the big value out of OPC is that they are able to engage with policy and legal and legislation areas. How do you prepare your drafters to be able to do that?
Well, as you know, we work fairly much on an apprenticeship training model, so we get in people with sort of a few years' experience doing something and then train them to be drafters. I think we would see the ability to work with these different models as one of the range of skills that we train people. So they obviously have to learn analysis of policy, the production of text, the myriad of rules we have, but also how to work with different instructing arrangements. So when people come to us, they tend to move around teams fairly regularly. So although we have a paired arrangement with an SES drafter and an assistant drafter, we change those teams regularly, which means even through that they'll see different instructing arrangements and also different ways senior drafters work with them. Our senior drafters are expected to be able to work with pretty much the whole statute book. I'll come back to a minor exception, and pretty much whatever instructing arrangements they're provided with. So again, it's that flexibility that the senior drafters would have developed over the years, which they're then expected to pass on to the assistant drafters. About the only area we have, in relation to specialisation, we have a number of drafters who predominantly do Treasury legislation. So within that, there's some who predominantly do corporation sort of stuff and some who predominantly do tax. We also find that some drafters from time to time will have a particular subject matter interest. So we've got one person who seems to do all the social security stuff at the moment, one person who loves doing the communication stuff. So to an extent, the drafters do work in particular areas, but the drafters aren't specialised. They're expected to be able to work across the full range. So I think the way that the drafters learn to work with the different teams is, as I say, through that apprenticeship style, which exposes them to the full range of both legislation we expect them to deal with and different working arrangements that we expect them to deal with. And it's really, I suppose from our perspective, it's a matter of having worked out how a particular project is working. You need to work out where the bits are or where the weaknesses are that need to be filled and how you can suggest that those be filled. So if you've got an instructor who, if you've got a sort of pure policy person with no legal knowledge, we'll often suggest that they either get their legal area involved or engage AGS to provide some assistance in that sort of area. So we try and work out where the weaknesses are and how we can work around those for the particular project.
Can I perhaps add something there, Peter? I think from the perspective of a senior drafter who sort of goes into a new project, almost the first thing you do is try to identify what resources the agency has and how it's structuring its function. And you almost get to a point where you've seen every possibility under the sun and you're just trying to work out how the arrangements are in this case, and then you'll actively decide who needs to be at the table, for example, when decisions are made, what might be the best way of managing this process, who needs support because they perhaps haven't got much experience and they might need to know that these are the processes that, you know, legislation approval will follow, for example. So there's a really quite an active process for the drafters of working out where the skill set is, where there are gaps that need to be filled or support that needs to be given, and in every case you almost do a bespoke project management because each agency organises itself so differently. Is there another question there?
Thanks. This question's for Susie. I was really taken with what you said about having only one chance to develop good explanatory material, and I was wondering if you could say a little bit more about what you think the key features of good explanatory material are.
I guess for me, so I mentioned that log of issues. I think that's really important. Obviously, that's about ensuring particular points that are made by the lawyers or the drafters working on the extrinsic materials are picked up. I don't know if you're allowed to do this anymore under the legislation handbook, so this might be an unhelpful suggestion, but I have seen projects where, someone might know the answer to this better than me, where explanatory materials give more of a narrative rather than a clause by clause. Even if you're not able to do that, I think a bit of a narrative at the beginning that tells the story and that connects the provisions rather than in addition to or instead of the item by item approach. Fairly basic point, but one that you still see probably the bulk of EMs do. Just, you know, regurgitating, restating, paraphrasing the provisions is, in my view, almost no assistance. Yeah, so that's why I mentioned the mix of skills, because bringing in a lawyer who's had nothing to do with the scheme, you're not going to get a good extrinsic materials there either, and I've seen that done, and sometimes that's simply done because there's no resources. So you get to the end of the scheme, you bring in 3 secondees and you say, here's the bill, write the EM. You're going to end up with something that might be technically correct but actually pretty useless from both a policy and an interpretive perspective. So in an ideal world, you would have... It can be drafted at a reasonably junior level. I don't mean to disparage the grads in the room, but my point was it's got to be someone who's been involved in the project. I think senior engagement, though, in clearing the extrinsic materials is really important, and appropriate input from the lawyers. And if you haven't had lawyers on the project, I think that's where I've seen this done well in in-house areas. Having an in-house area which does, you know, look at and interrogate the extrinsic materials, because OPC, as you probably know, have no role in that. So, yeah. One final tip I would give is be careful about your editorial process. So I was asked to write the particular parts of extrinsic materials which are about the constitutional basis provisions because they're really tricky, and so I wrote what I thought was some quite good text, which talked about the quarantine power, supporting the Biosecurity Act, and the editors substituted quarantine for biosecurity, which is a completely different thing. It's not power under the Constitution, as you probably know. So 2 years later, when I went to use those extrinsic materials, I was like, So, even down to the editorial, things can slip up at that moment. Simon, did you want to add something?
Yeah, we do a lot of thinking about this. So one of the challenges with extrinsic materials is that you've got quite a few audiences to deal with. So one is just members of Parliament, but there are also the scrutiny committees. There's the judiciary and other people who use it in that sense, and then there's the broad mass of kind of regulated communities and people like that. So you're trying to talk to a whole bunch of different people about the same thing in different ways. So that is one of the real challenges, and it can be a reason why people tend to stick with a fairly safe descriptive approach. But I agree with Susie, a description of the legislation is not much better than reading the legislation, so why bother doing it? So this sort of concept of what an actual explanation is and how to do that in a meaningful way is really important. One of the challenges we have is we're producing a lot of this stuff, and maintaining consistency across them is an important issue for us. We have pretty regular interactions with the scrutiny committees up at Parliament House to try and ensure that we're meeting their needs and getting that kind of input. And it's a work in progress. We're not trying to pretend it's perfect, but it is a very challenging thing to get right. Any kind of good writing is really, because you're trying to write for your audience. The difficulty here is you're writing for about 4 or 5 of them, and doing so in a fairly constrained format. The other thing I would say about it though is it is a very good way to train people to write well, and there is the potential to be innovative about these things as well. So in the explanatory memorandum that I probably had most of a hand in, which was for the carbon pricing legislation in 2011-12, we included diagrams and lots of tables and all of those sort of things to make a complex system more tractable for the reader. And that's a real challenge for us in Treasury as well. We'll have tax bills that will be 2 or 3 pages long but require ex-memos of 60 pages to explain how they work. And that is a real issue for us to manage. But we're not the only people in this boat. And the challenge is that there are a lot of different approaches adopted across the Commonwealth, some pretty archaic, and it's an area that we could all improve on.
I might just add one more thing to that, which is based on the projects I've worked on. That's why I think the Treasury model, I'm quite attracted to that, and I've seen that to a lesser extent, less the law design, but that legislation function actually being centralised in a department and recognised as a skill set. Otherwise, the EM's always written by someone who's never done an EM before and perhaps cleared by a legal area who've had nothing to do with the project. That's suboptimal. I think that demonstrates that extrinsic materials are part of that skill set as well, in my view.
Is there anybody else with any questions? Just up here.
David Ball from the ACCC. A question for Simon. You said at the start of your talk that one of the things that Treasury looks at is the sort of the broader systems type issues that a particular piece of legislation might raise. I'm wondering if you could unpack that a bit and give some illustrative examples.
Well, probably the best example is around the tax system. So I won't pretend that any of our schemes are perfect. They're large and complex and sprawling, and they reflect various sort of interests and fads of governments throughout the years. But one of the things that we're trying to do by drawing together the law design function is try and minimise that propensity for sprawl and complexity in the legislation. Part of the difficulty is that once you've got a large scheme up and running, it would be nice to sort of every 10 or 20 years sort of pull it all apart again and start again. And certainly when you read parts of the Corporations Act or even the Competition and Consumer Act nowadays, that temptation is a strong one. But we can't just sort of park these things and sort of beaver away and produce a perfect product. They've got to work in the real world in real time. What we're trying to do, and where it's most developed is in relation to tax, is ensure that when we make changes, we're not creating knock-on effects and problems for the way the system operates in practice, or they're creating potentials for loopholes and avoidance mechanisms and all of those sorts of things. So having that system-wide perspective is really important. And for us to do that, the relationship with the relevant administering agency is critical. So with the Tax Office, we have a very long-established and quite effective protocol around the way that we deal with them on legislative issues. The Tax Office is an organisation of nearly 20,000 people, so it has resources to dedicate to this task in a way that smaller agencies may not. But they have a centralised function that thinks about these things from their point of view, but also coordinates the consultation across the Tax Office to ensure that the sort of various practical perspectives are brought in. We're developing a similar mechanism with ASIC at present. And the idea there is that we're not producing changes to these laws in isolation from the broad context of them, because the damage that could be created by doing that is sort of manifestly, because we've seen it happen in the past, problematic, not only for the administration of that piece of legislation, but in some cases for the economy as a whole. Thanks,
Simon. I'd like to thank our speakers. I think we might wind up today's seminar there. It's a significant effort to produce a paper in the middle of a busy schedule, so I'd really like to thank our speakers today, and thank also for the participants for attending and useful questions, because I think the questions and answers are often some of the most useful parts of these seminars. So thank you very much for attending and participating.